6034. The promo code Mike G, like we like to sing. For the best night's sleep in the whole wide world, promo code Mike G.
Welcome back to the Mike Gallagher Show. This is Nick Adams filling in for Mike Gallagher. What a beautiful, beautiful, beautiful day it is to be an American. Just a few days out here from the Christmas day that all of us wait for all year long. I can't wait to see what Santa is going to bring under the tree. Last year he gave us Christmas a little bit early on the 8th of November with President Trump, and that's really been what we've been talking about so far this show, looking at the president and the Trump administration and how they've been faring over the last year or so since assuming office. Hard to believe that whole day.
Oh my goodness!
DC, I was there.
Alice, this is David Tulis, and thanks for giving me a couple minutes every time. I wanted to make a point about an important concept, letting you pin personal liability upon a state actor, and it's called administrative notice, and it's something I've written about and I've thought about a great deal, and in fact I'm writing an administrative notice myself that's probably going to run to 30 pages, maybe 40 if I can't contain the citations. But administrative notice is a vehicle, is a means whereby a state official, a state actor, is notified of the law. And you say, well, what's the big deal about that? Everybody knows what the law is, and every state official has policies and statute and rules to follow about his job. Well, maybe. Probably 60 to 80% of state action, I'd like to suggest, is ultra vires. It's outside of authority. True probably on the federal side, probably on the state side as well. And what happens is that actors, these state actors, think that, well, this is what I do, and this is what my predecessor did, and this is what the other people in the office do in the way of making the people of our state jump, right? Make them jump, make them hop, make them pay, make them comply, and so on. And often there is no actual legal basis for that claim upon the citizen or the citizen's attorney, right? We get the attorney involved, and the accountant, and so on. And so you have a lot of state action that runs against the liberty of the people, right? We are, after all, a free people. We have what's called a free government. Free government implies government not beholden to private financial or moneyed interest. In other words, a government that's free to serve the people, to represent them, and to provide the limited number of laws that they might need to make their state more prosperous and their liberties more secure. That's what the ideal of government is. We have, though, in our day, the state, which is a different entity entirely. And I'm at 800-8949, 800-8949. And the ideal of letting the state actor know what the limits are, you say, it's useless. But no, it's not useless. It's important that he know what the limits are. And state actors will pay attention if you make it clear, that the statute that they're involved in is limited in what it grants them authority to do. They can't just do whatever they want. They're bound by law. Bound by law. That's what rule of law means. And we have Republicans and Democrats who say nice things about rule of law, but don't really believe it. They don't really believe in it. But I do. And I want you, my listener, to believe in it too. And make sure you take advantage of Rico's Pizzeria and Italian cuisine today. Today, go by there. Try out this little restaurant at the Calvary. We're in the same building as Calvary Church on Hickson Pike, between Daisy Dallas and Dallas Hall. A great little restaurant. Very generous portions. Rico's Italian Pizzeria, Lala Esparza, and her team would love to serve you. Make sure you go by there today and get the 2-for-1. Now, administrative notice is the means whereby you, even if you're in prison, on a 25 years aggravated assault and robbery charge, even you can make a state actor adhere to the law. And I'm saying this because there's an inmate, my correspondent, by the way. Here, David Tulis has inmates who are his correspondents. And don't forget, the word correspondent simply means someone who writes you a letter, right? So I have 3 people who are writing me letters from the hellhole of the state prison system. It is a hellhole and it is hell in the form of bureaucracy. Something worthy of the Screw Tape letters, right? It's straight out of the Screw Tape letters by C.S. Lewis. And his name is Grenda Harmer. He's making gains in his understanding of this vital method that I want to mention just briefly to you, okay? Just briefly to you. Now, administrative notice connects two people. It connects them in a very healthy way for you. If you're a prisoner, or if you're just a businessman, or if you're a private person, whatever. If you are the victim of state action, right? If you are the target of our virtuous state, administrative notice is a vessel for you. And what it implies is that you tell the state actor what the laws are. That's just it. You simply tell him what the rules are. That's it. All right. You're not making a claim. You're not making a grievance. You're not telling the story of how he's abused you or anything like that. You're just laying out the law. And it's done administratively, because that's where the state actors work. They work under administration, in administration, under, you might say, under the level of constitutional rights, right? They work in an area where the state has jurisdiction, and that is in administrative law under UAPA. UAPA is the Uniform Administrative Procedures Act of your state. It is in Tennessee. Every state is the same. And state agencies work in that jurisdiction only. And they work upon people who have entered, who have lowered themselves into that jurisdiction, who have given up some kind of right to lower themselves legally, lower their standing, and enter the administrative realm of law, where they're bound, in equity, they're bound to obey. Okay. Now, this prisoner, Grenda Harmer, has given me a very fine administrative notice, and he's making progress. I'd say this is, I'm not an expert in administrative notice, okay, but I think he's made progress, and this is a very, very good use of this procedure, this protocol. What he's done is, in a notice to Tony Parker, Tennessee Department of Correction Commissioner, and the warden of the hellhole in which he resides, which is Morgan County Correctional Complex, dated December 18. First, he cites the Tennessee Constitution on the erection of safe prisons, the inspection of prisons, and the humane treatment of prisoners shall be provided for. That's what the language says. Now, he goes to discuss public servant in citing Tennessee Code annotated 39, etc. Okay, a public servant means a person elected, selected, appointed, employed, or otherwise designated as one of the following, even if the public servant has not yet qualified for office or assumed the duties. And this is the one he mentions, an officer, employee, or agent of the government. Okay, that's one definition of public servant. Now, in a prison, is there abuse? Yes, rampant abuse in Tennessee prisons, rampant. There's sexual abuse, there's gang abuse, there's administrative abuse, there's abuse by staff people who are employed by CoreCivic, the slave master, the corporate slave master, publicly traded, by the way. You can make a dividend every quarter. I think it's a dividend-paying investment asset. Now, he says, Grenda Harmer does, in citing further on the statute, a public servant commits an offense who, with intent to obtain a benefit or to harm another intentionally or knowingly, okay, number one, commits an act relating to the servant's office or employment that constitutes an unauthorized, got that, an unauthorized exercise of official power. And number two, commits an act under color of office or employment that exceeds the servant's official power. Number three, listening to this, refrains from performing a duty that is imposed by law or that is clearly inherent in the nature of the public servant's office or employment. And number four, violates a law relating to the public servant's office or employment. Now think about this. Let's say you're Douglas, you're Sean Phillips, the warden. You're getting this notice, and it's telling you these are the things that you're bound by. Okay, you are committing an offense if you knowingly or intentionally harm someone in your authority. Okay, what's happening is just think for a second. What's happening is that the man Sean Phillips, born to the Phillips family somewhere, to a Mrs. Phillips, his mother, he is a man. He's a human being. He's made in God's image. He is an enfleshed soul. Right? He's a soul. He's a Homo sapiens. He's a male of the male sex. That's the man. Now, Sean Phillips as warden is a separate person. Legally, it's a separate person. It is an office and office holder. What you do with administrative notice is to connect the man, the enfleshed soul, Sean Phillips, the warden, with the office. And what you're doing is you're allowing the law to shift personal liability and culpability to the individual. Yes, you're with your notice telling the individual human being that he personally is liable for abuses of the authority exercised by the warden, Sean Phillips, right? The warden, the man in the office, exercises authority, damaging to individuals, damaging to people who are protected by law. Prisoners are protected by law. You are protected by law. You, my listener, are protected by law. And the notice is 2 pages long, and you're getting a flavor of what it looks like, right? It's just a dreary recitation of the law. It could include, of course, policy. It could include court decisions, and it could even include a quote from a law review if you have same in reach. 3916 says a public servant acting under color of office or employment commits an offense who intentionally subjects another to mistreatment or to arrest, detention, stop, frisk, halt, search, seizure, dispossession, or assessment, or lien when the public servant knows the conduct is unlawful. What you're getting at is the state of knowingness. With notice, you make the official not be able to claim that defense. You got that? That's the key point. The key point is the public official can't claim the defense that he didn't know and it was unintentional. You see what I'm doing here? This is important. 800-8949, 800-8949. So Brenda Harmer, the state slave, goes on to cite these kinds of things. You are a public servant acting under color of law if you intentionally deny or impede another in the exercise or enjoyment of any right, privilege, power, or immunity when the public servant knows the conduct is unlawful. This is good stuff. This is juicy stuff. Now, what we need to have in Chattanooga, I better not go into this direction because I'm going to assign myself the job of writing a notice to the mayor, okay? But a radio broadcast is not administrative notice, so it has to be done in writing, and it has to be called administrative notice for Mayor Andy Burke. Mayor Burke, it would say, here's what it would say, and it's going to come in the mail in the next year, okay, if I can just get around to it, in God's providence, if he gives me breath in the next hour or the next day or year. And that is that the police department has in its policy the provision that people who are arrested be Mirandized. It's on page 6. Mayor Burke, OPS 42 arrest procedures approved is meeting CALEA standards, right? And it's approved by former Chief Fred Fletcher, who signs his name on the dotted line there on page 13. Now, page 6 says that Miranda has to be given as a warning to people who are under arrest. And we're looking forward to seeing the arrest video of Nikki Lewis, who works at Glass House Cooperative, an artistic effort bringing higher culture to a shabby part of the city. And Cameron Williams, Grimy Williams, C. Grimy is his hip hop music name. An arrest that took place in March. A story broken, by the way, by TV9. TV9 providing a great service here in Chattanooga by having its Driving While Black or Walking While Black story. March 25 arrest. The officer, E. Buckman, and these two people are treated in a peremptory, proprietary way. What that means is they're treated as if they were property. And the officer, without showing any ill temper, without showing visibly any peevishness in the video, acts in a very peremptory and peevish way to arrest two people who have done nothing wrong but talk to him. This is the talking while black story in Chattanooga that TV9, to its good full credit, has aired for us. TV9 has aired for us this story. You can find a version of it and a link to it, by the way, at our chief sponsor, Nooganomics.com. Nooganomics.com, which allows me to say that I'm the blogger with the biggest pen in Chattanooga, the blogger with the biggest pen in Chattanooga. Whenever a person has been arrested, he should be given the Miranda warnings. The Mayor Burke's policy says, if the person arrested does not understand English, etc. And here's what the warning says. You have the right to remain silent. Anything you say can be used against you in court. you have the right to talk to a lawyer for advice before we ask you any questions and to have him with you during questioning, etc. There are 2 more points. Although these warnings must be given only before interrogation takes place, it says it is good practice. It is good practice to give them immediately after arrest, thereby making any offhand remarks or other voluntary comments by the offender admissible in court. Notice what the issue is: admissibility in court. And the High Court in Tennessee has ruled in State versus Garcia 2003 and State versus Raspberry 1982 on arrest. Okay, arrest is a large topic, and Tennessee jurisprudence, the Encyclopedia for Tennessee, which costs, by the way, $2,500. If you want to buy me if you want to make me a more useful man, you, my listener, I would love for you to buy me a copy, a set of Tennessee jurisprudence encyclopedias. I would be so grateful if I could have that at home. The current edition with the updates inside the inserts. But in there, we learn that arrest equals stop equals seizure. And in the arrest story of Cameron Williams, C. Grimy, the hip hop artist, and Nicole Lewis, we have an abuse of this rule coming from the 1966 ruling Arizona versus Miranda. And it is, let's admit that this is a pro-state ruling, that the Supreme Court wanted to continue the abuse of policing upon the American people. And so it had a workaround, and that is the Miranda ruling, which says, well, we can let police abuse you corporately. We can let punitive policing continue with arresting, filling our prisons, creating the police state that we have. But the officer has to tell the ignorant person he's arrested what his rights are. Now, it's a pro-state ruling, and I'm getting off track here, but it's a pro-state ruling because it lets that whole system continue. And the cops have the advantage, once they've Mirandized somebody, that they can use anything that the person admits. Anything the person says, anything the person gives by way of identification, documentation, or other, all is done voluntarily once the Miranda warning has been given. You give the Miranda warning, and now it's all admissible in court and can be used to convict that person. Miranda, though, if seen from our perspective, right, as the victims of the state, right, state victims, we need to have that given to us so that we won't be chatty with the officers, so that we will be guarded. That's what we want to be, is guarded. And that's what how Miranda is to our advantage, to have it enforced as policy in Chattanooga. Mayor Andy Burke is rejecting my call to have everybody Mirandized. And that means everybody, the moment the blue lights come on, Miranda is required. Because if you're stopped on the road, you are stopped and arrested. That is the same thing. A traffic stop is an arrest, is a seizure. They are the same thing. They are the same thing. And anything you say can and will be used against you. And that's what people need to know. My wife, who was stopped by an officer, all casually, right, all informally, she was traveling too fast. She is a driver, by the way, legally a driver, though she was using a car dressed up as a vehicle for private purposes. That's the family car. And even she should have been Mirandized because she was effectively under arrest. She was not free to leave. And the key question is always, am I free to leave? If you're not free to leave, you are under arrest, even if the cop tells you, well, we're just detaining you for a moment. If you're not free to leave, you're not free to speak, okay? If you're not free to leave, you should keep your trap shut because everything you say can and will be used against you. Do not speak. Do not answer questions. Answer no questions. Make no admissions. Do not allow access to your car. Do not allow access to your property without a warrant and without a lawyer present. And you may say, well, I don't know any lawyers. You don't have to have a lawyer or know any lawyers or have a list of lawyers on your phone like I do. My cell phone has about 3 screens worth of lawyers on it because I talk to lawyers a lot when I can. And so I like having them available for interviews. And you don't have a lawyer, but that doesn't matter. Just say, I make no statement. And you cannot, get this, you cannot have the assertion of a right be used as evidence of a crime. In other words, the assertion of your God-given, constitutionally guaranteed, inherent, unalienable rights cannot be converted into a crime. It can't be done. And anytime the law is used to attempt to make that happen, you have to yield a right to assert a privilege, right? The pretended privilege of driving in a car for private purposes. That's all a privilege in the privileged world, all under administrative law. If you if you don't assert your rights, you don't have them. And so what we need to have is people who are belligerent claimants in person and who want to be respected by the officer. And the officer is respecting people by giving them the Miranda warning. Now, administrative notice could solve this problem because once they're notified, they know what the rules are. David Roddy could be notified. The mayor could be notified. That's just a little project. But, I've got some days off ahead. Maybe I'll have some time. This is David Tulis. I do thank you for giving me just a minute of your time. Love your neighbor. Buy local. Brought to you by Nooganomics.
The Tennessee Valley's news talk leader. Nooga Radio. Digital FM.